Hey everybody, welcome back to AI DIY, or AIDIY.tech is the website. I'm your host, Matt. And can you be sued for creating songs on Suno or Udio and then publishing? Let's go ahead and talk about this. Okay, everybody, welcome back. Now, the reason I'm bringing this to your attention is I had a user, or a subscriber, I should say, someone that I speak to from time to time through my website. We'll say his name is Robert because his name's Robert, but I won't link you to his page because he had some concerns over whether the record companies could take legal action against his claim. Now, first I want to say this is just a topic that I find interesting. I'm not a lawyer. Best I can say is, 24 years ago, I was just about to finish a criminal justice degree, just fell short of that. I've been in business for years and I review contracts often. I don't do anything with copyright law. I'm not a lawyer. This is not legal advice. This is just a topic that I find interesting. So Robert sent me the link to Top Music Attorney's video on YouTube that basically talked about a broad bunch of topics that had to do with Suno's terms of service. Now, I don't believe they talked directly. She didn't say whether anybody could sue you directly or anything like that, but I'm just going to broadly cover 5 points or 5 key takeaways from that. So the first point is Suno has broad licensing terms. Now this is what I'm interpreting out of that, and you can go and watch the video. I suggest that you do. You should be across this stuff, but they're very broad licensing terms. So if you look in the terms of service that make it very clear without the 800 billion page document that they have, that if you have the free version of Suno, you don't really own the songs that you put out, but if you have the paid version of Suno, you own those songs. But if you look deep into the terms of service, they also say that they reserve the right to use those songs however they want. So you own them, but they can publish them however they want in whatever way they want and sublet them in other ways they want. Okay. Point 2 was exactly what I said before, the commercial agreement that if you have the paid version, you own them, and if you have the free version, you don't own them. That's basically that. That's my second point. Okay, number 3. Now this is the part that I guess people are concerned about, the loose wording. So what Suno is saying is ownership in the copyright challenges, they're not guaranteeing that they're not going to produce their what they call outputs as non-copyright material. So you're kind of on your own in that case, and we'll address that further in the way that I feel, but I just wanted to talk about the 5 points that she's making in this. Okay, number 4, account termination rights. And what they're saying here is, and I've seen this, and I've basically warned people in one of my shorts, and I plan on doing, I'll warn you now, don't do things that you know are wrong. Don't go uploading YMCA and up into their sampling and say, I want a song that sounds like this, or Metallica or something like that. Accounts are being banned. They're just banning them, deleting all your songs. No chance of fighting it. Suno's in a massive lawsuit right now with the industry. They're not going to be giving the industry free reign and saying, look how terrible we are in enforcing your copyright. We don't even care. Any sort of hint that you're violating the copyright, they're going to terminate your account, and they have been. And the 5th point that she makes is you can be publicly identified as having created AI music. That you agree in the terms that you can be identified, they can point that song is made by you, and so on and so forth. So those are 5 points or 5 key takeaways that I took out of it. There was a bit more, and I definitely suggest that you go and watch that video. It's a very interesting one. Like I said, I actually love this stuff. I love sort of figuring it out at the moment. So that's that. So since that video's been put out, it's not just Robert that's reached out and contacted me. I noticed there's been a lot of content and a lot of people asking questions about, can I be sued? Will I be sued? So I just want to make it a point that it is a hot topic at the moment. So let me just think about some parallels or some things that I can think of, because I'm old now, that you can sort of draw as a parallel to that, right? Draw to a parallel and just as a discussion. And I'd love to hear the discussion points down below in this and what you think as well. So I'm old enough and I'm not that old, to think about Napster, right? Now, if you don't know what Napster was, it was one of the first online software bits that you could download music. This is before streaming things like Apple Music or Spotify and all that stuff. So you could basically just download these songs. It was like really exciting. Like I don't have to go to the record store anymore. I could just download this music. And the music industry was obviously quite upset about that. And they went to Napster, they took it down. Like it was, at the time, it was terrible. Then obviously things came in their place. But I just want to describe the difference that I see between Napster and Suno when you're talking about a like for like. It's music, it's copyrighted material, or it's not, whatever you want to think. So Napster, you could say, you know, Metallica was the ones, this is an exact Metallica song, right? This is Ride the Lightning that's being taken from this person, given to this person, and they're doing it for free, right? You could say Ride the Lightning's being used, or whatever other Metallica song. So you can say that's that. The difference I see is Suno maybe produces a song that sounds 12% like James Hetfield, and then a whole bunch of other percentages mixed in to that. The music is about 8,000 other versions of other bands as well. So like, is a music industry executive gonna say I can sue for that 12% because in my opinion it sort of sounds a little bit like James Hetfield? I don't think so in that case, right? Okay, so now you know you heard my Napster comparison. But let me tell you, copyright law is complicated, right? Because on one point you have copyright law, it's there to protect people that create a thing. But there's also something that I believe is these bottom feeding, and I'm going to give a couple examples of bottom feeding. Absolute bottom feeding copyright attorneys and people that use copyright in ways that it wasn't intended. I've got a friend that owns a really cool blog site. He doesn't make any money at this point anyway, and he hasn't for years, and posting things about cars. He writes from scratch. He doesn't use ChatGPT. He writes from scratch articles about these classic cars. Then he'll go to Google, find an image, and he'll paste it up on his blog site, right? So what happened was one of his articles was found by these bottom feeding attorney, I don't know, let's call them bottom feeding attorneys, like call centers, I'll say, where they work on behalf of these image owners. And they contacted him and said, oh, you use this image. And he said, yeah, but I'm not making money. They said, we don't care, pay us $5,000. We went to people we know in the legal industry. We reached out on people on Reddit and all these things, and everybody said, you have to pay him. The best you can do is negotiate. So he negotiated down to $2,000. So there's an example where, you know, they'll just reach out, and if you can fight it, you can fight it. If not, not. You also have to take into consideration that at some point when the record labels do get some sort of, you know, idea of how they can go about doing that, if they do, in my opinion, I don't think they can, because like I said, it's that 12% Garth Brooks or James Hetfield or whatever voice. But I think if they do get some sort of leverage, as seen in the past, and I'll just link you to a couple articles, or you can scroll through them here, back in like 2000 or 2000, the early 2000s, the record labels were going after children, grandparents. I think there was a lawsuit of $220,000 for sharing like 24 songs or something like that. The idea wasn't for the record industry to make $220,000 off of it. It was very much to publicly scare people and to stop doing what they're doing. So all that being said, I just want to summarize. At this point, to me, in my opinion, I don't think there's enough really, unless you copy a song almost exact, in which Suno is going to ban you anyway, you're not going to have access to that song. I don't think it's really possible at this point with what they have to sue you for a fraction of a percent of someone's song. That being said, the predatory nature of the music industry and copyright attorneys is they could possibly find a way. And if they do, they're going to be going after people that they can make examples out of, given their shady history of doing that in the past, in my opinion. So take it for what it's worth. You know, you're like 1 in a 7 million billion cajillion, I don't know, chance of being sued if the slight fraction of a percentage that they can find something concrete to do it could be done. Now, I think you'd probably get warnings of that first. I think you'd, like right now, the record industries are really going after Suno and Udio for that. If they're not successful with that, and signs point of them not being successful at that as well, because OpenAI and ChatGPT just won a case against like media companies, because media companies, ChatGPT, OpenAI, borrowed from, say, newspaper articles and magazine articles, and the courts just said, yeah, no good. And I see that as being similar. But anyway, these are my opinions on that. I would love your feedback in the comments below, because I'd love to have a conversation about that. And yeah, thank you very much for tuning in, and I hope I can catch you next time.